Hello everyone, my name is Krishna Saurath and welcome to LawPutra YouTube channel and Jai Hind guys. So now we're discussing on the topic of affidavit under order 19 CPC, and as well as we are going to discuss its essential parts. Also at last we are going to discuss some case laws. So let's begin with the topic. Okay, first of all, the expression affidavit has not been defined in the code. It has been commonly understood to mean a sworn settlements in writing made especially under oaths or an affirmations before an authorized officer or magistrate. Stated simply, an affidavit is declaration of facts made in writing and sworn before a person having authority to administer oaths. ठीक है? Every affidavit should be drawn up in the first person and should contain only fact, not unnecessarily writing. Okay, it clearly means first of all it should be in a written form. Secondly, it should be written under the eye of magistrate or authorized person. Also, uh, also it should contain only relevant facts. Fourth one, it should be written by every party or person. Okay, now I hope that you understood with the topic of affidavit. Now we're going to discuss some essential parts. Okay, let's start it with the first point. It must be a declaration made by a person. Second point, it must be related to fact. Next point, it must be in writing. Fourth point, it must be in first person and it must be sworn or affirmed before a magistrate or any other authorized person. Okay, an affidavit should be confined to such fact as deponent is able to prove his personal knowledge. Rule 3I of Order 19, however, allows the deponents to such facts in interlocutory applications which are based on belief. Okay, as mentioned above. Okay, and I hope that you understood with the essential points. Okay, and I must recommended you to note it down some points that mentioned by me so that you can revise it later. Okay, now I am moving to some case laws. Okay, let's begin with the first case law. So first case law is with the case of Kantesh, S.P.G versus Rashtriya Girni Khamgar Singh. Citation 1961 AIR 571. So in this case law, it is beautifully quoted as affidavit as evidence. So why affidavit is quoted with as evidence? So let us find the answer in the explanation part of this case. So in this case, it is treated as evidence with the meaning of section section 3 of Evidence Act. In the matter of Kantesh S.P.G versus Rashtriya Girni Khamgar Singh, citation 1961 AIR 571, as I have told earlier. Okay, it was Supreme Court that affidavit can be used as evidence only if the court so order for sufficient uh, reasons, namely the right of opposite party to have deponent produced for cross examination, and therefore an affidavit cannot ordinarily be used as in absence of specific order of court. Okay, now I hope that you understood with the first case law. Okay, now begin with the second case law. In the second case law, it was Amar Singh versus Union of India. In this case law, the Supreme Court has issued some guidelines to courts to carefully scrutinize the registry and all affidavits, petitions and applications, and reject all those petitions and applications which are not meet the requirement of order 11 of Supreme Court rules. Okay, and also the Supreme Court has also highlighted the importance of affidavit in this judgment. So I hope you understood this whole topic. Okay, if you and from this, now I will end my topic. Okay, so if you really like this topic, so please like the video, share the video, and subscribe the LawPutra YouTube channel. And Jai Hind everyone. Okay.